So we need to talk about a new case that is in front of the Supreme Court, and this case and what happened in this ruling should raise alarm bells for anyone who cares about constitutional rights. Just months ago, the Supreme Court issued a 9-0 unanimous ruling in a case involving excessive force and the Fourth Amendment. The court sent the case back down with clear instructions to the lower court, but now the plaintiffs have filed for brand new Supreme Court review, and they're asking for the Supreme Court to step back in this case, arguing that the Fifth Circuit essentially ignored what the Supreme Court said in that 9-0 decision. And now there's another procedural development that may accelerate how quickly the court looks at this case. So let's break down what is happening in this critical challenge. Now, before we jump into this video, if you want to support the channel, one of the best ways to do that is simply to subscribe. You can also click the like button. That just tells the algorithm that you appreciate this content, and so it should share it to more people. I also want to thank one of the main supporters of this channel, which is First Form. You guys know that First Form's an amazing company. They support the Second Amendment and what we talk about here on the channel, but also they have amazing supplements. So if you're trying to get healthier, if you have a New Year's resolution, I highly recommend that you check them out. You can do that using the links down below in the details section, also in the pinned comment. And right now, if you order anything through that link, you're going to be entered into a random drawing to potentially win some channel merch, patches, and things like that. Now, as I mentioned in the intro, in this video, we're going to be talking about a critical case called Barnes versus Felix. And this case centers around the Fourth Amendment and when police can use deadly force. So in this case, an officer pulled over an individual, Ashton Barnes, for what began as a minor toll violation involving a rental car. Now, the officer here ordered that Barnes exit the vehicle. The individual here, Ashton Barnes, opened the door, acted as if he was going to comply, but then he attempted to drive away. The officer reacted in a split second and decided to jump onto the ledge of the car as it was pulling away. In response to that, him being on the vehicle, he decided to pull his weapon and fire 2 shots at Ashton Barnes, and Barnes was fatally struck. Now, his mother, in response to this incident, decided to file a lawsuit against the officer under Section 1983. So this was a civil rights lawsuit, arguing that the shooting constituted excessive force under the Fourth Amendment. Now, originally on review, the lower court ruled in favor of the officer using something called the moment of threat doctrine. Now, under that rule, courts focus only on the exact moment when deadly force was used. Everything leading up to that moment is actually ignored. So using that narrow framework, both the district court and eventually the Fifth Circuit ruled in favor of the police officer. That then led this case to go to the Supreme Court for the first time. And the Supreme Court on review unanimously rejected the whole moment of threat doctrine in that rule. So the Supreme Court justice held that excessive force cases must be evaluated based on the totality of the circumstances. So in other words, courts must look at everything leading up to the use of force, not just the final split second. So they rejected the whole moment of threat doctrine. And again, this principle comes from the long-standing Supreme Court precedent requiring courts to evaluate the full factual context surrounding police encounters. So the Supreme Court sent this case back down to the Fifth Circuit with very clear instructions. Reevaluate this shooting, reevaluate this case using the totality of the circumstances approach, and decide if this case should move forward for a full trial. But after the case returned to the Fifth Circuit, something very unusual happened. The panel in the Fifth Circuit decided to not hold oral arguments on this new issue and new development based on what the Supreme Court said. They did not request full merits briefs based on what the Supreme Court said in that 9-0 decision, and they did not send the case back down to the trial court. Instead, the panel issued a new decision, ruling once again in favor of the officer. But this time, they ruled in favor of the police officer using a different theory. The court reasoned that because Barnes attempted to flee in the vehicle, he created a risk of flight that could endanger others on the roadway. Therefore, they believed that the officer's use of deadly force was reasonable. According to the petition that was just filed to the Supreme Court in this case, this new ruling by the Fifth Circuit effectively creates this per se rule allowing deadly force anytime a suspect who is fleeing in a vehicle might pose a potential danger. And also there's a key issue where if someone is potentially suspected of fleeing or, they believe that they may flee, deadly force could potentially be warranted. And that was what is so concerning about what the Fifth Circuit said. And that's why this is now heading to the Supreme Court. The new petition argues that the Fifth Circuit's risk of flight doctrine conflicts directly with Supreme Court precedent. In particular, they point to cases like Tennessee versus Garner, which held that deadly force cannot be used simply because a suspect is fleeing. Instead, deadly force is only justified if the officer has probable cause to believe that the suspect poses a significant threat of death or serious physical harm. But according to the petition, the Fifth Circuit's new rule effectively lowers that standard way below what the precedent says. Instead of requiring a serious threat, the court's reasoning suggests that the risk of escape alone could justify deadly force. And the petition argues that that fundamentally changes what the Supreme Court has said in their precedent about what is actually required. So now that this case is back in the Supreme Court, they're seeking Supreme Court review. Momentum is now shifted for the defendants to have to respond, but there has been a new procedural development that could also affect how quickly the Supreme Court moves on this case. The defendants have now filed a waiver of response to the cert petition. Now, what this means very simply is that the defendants here are telling the Supreme Court that they do not intend to file a brief opposing the Supreme Court review unless the court specifically orders them to do so. So that is pretty common, but it also means that the Supreme Court can move this case to conference without waiting for a full briefing schedule, or they look at this case once again, look at what happened already at the Fifth Circuit level, look what happened after they issued their order and send this case back down, and then they can likely request that the parties here, the defendants, need to file a response. So if the justices want more information, they can still request that the defendants here file a response. But the waiver allows the court, if they wanted to act immediately, if they really want to, if they don't want those additional briefs, if they see something wrong with what happened at the lower court level. I don't suspect that that will happen. I think that they will request that the defendants file a response. So the petition also argues that the Fifth Circuit's new rule creates a conflict with other federal appellate courts. Other circuit courts have held that shooting a fleeing driver is unconstitutional unless the driver possesses an immediate and serious threat. But the Fifth Circuit's ruling here essentially suggests that the risk of flight alone may justify deadly force. And that creates a very serious split in how courts apply the Fourth Amendment across the country. And when splits like that emerge, especially involving constitutional rights, that's exactly when the Supreme Court often decides to step in. So where does this leave us with this critical case? Well, now you have the Supreme Court who issued a 9-0 unanimous ruling in this case already. The lower court, was ordered to re-review this case in light of what the Supreme Court said. But on re-review, they reached the same outcome, but they used a different legal theory. And now a new petition is asking for the Supreme Court to once again intervene in this case and review what happened. Like I mentioned, the defendants here have filed a waiver where they're saying that they will not respond to this petition unless ordered to do so by the Supreme Court. And now I suspect the Supreme Court will take an early look at this and say, yes, defendants, you need to file a response because we want to know what happened after we issued our order. And really in this case, a big issue and a broader issue is more than just, the use of force and things like that. One of the big questions is whether lower courts are faithfully applying Supreme Court precedent, or are they simply creating new doctrines that reach the same outcome the Supreme Court has already rejected? So are they continuing to circumvent what the Supreme Court said by just coming up with new theories? And that is something that is being brought to the Supreme Court. Now the Supreme Court will decide whether they want to grant cert once again to Barnes versus Felix. If they do, the court will likely address a major constitutional question. Can police use deadly force simply because a suspect might flee in a vehicle? Or does the Fourth Amendment require a real and immediate threat before deadly force can be deployed? So those are the latest developments in this critical case, Barnes versus Felix. As we get more information, as it develops more, I will let you guys know. If you like this video and you'd like to support the channel, one of the best ways to do that is simply to like, comment, and subscribe. All of those things help to fuel the algorithm and just tells the algorithm that you appreciate this type of two-way content, and so it shares it to more people. But as always, thank you so much for all of your support. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.